I was also with the railways, training of law officers and law assistants. And most of my students are today High Court judges and occupying very high positions. But I am the only person who could call High Court judges also Yentra Bhavanava. And I used to call them by name. And I had the cheek to say, one of the judges, I don't want to name the judge. He was my student. I told him, for example, most of you know when you apply for legal aid, there is declaration. You have to pay half the market value as court fee when it's concerning property. I said, sir, the wife should not lose her husband. She has lost her sixth sense. And the children who have been deprived of the affection of their father have been deprived of that. But asking them to part with half the market value and pay the court fee is nothing but a daylight robbery. But that particular judge, I don't want to name him also, he recently resigned from the Electricity Commission also. And he said, what to do, sir? No one has challenged it in the Supreme Court. Why don't you do it? Then I said, sir, I don't have the cheek, I don't have the age also to challenge anything because I'm already past 75. And one more feather in my cap was, I was the first person from Andhra Pradesh who was selected for the district judges directly at the age of 27. Again, I was selected at the age of 29. And again, I was selected at the age of 31. But my father was stopping me and saying, why do you want to become a judge? You will have to bow your head before everyone. Till now, I have not bowed my head to anyone, not gone to any judges for any obligation. Always my head is straight. I expect you also to adopt the same attitude, irrespective of the caste, creed, or race to which you belong. Now we go to the subject in the proper perspective. First and foremost is the art of cross-examination in civil matters. Civil matters it's a vast ocean. The question is you cannot fetch water also from that. Because in India we see everyday law is born. Please remember when we studied, we didn't have so many laws. Like for example, you've got the PMLA, you've got the FEMA, FERA, Competition Commission, so on and so forth. But when we studied the general law. Our knowledge was something like limited knowledge. But you people are fortunate enough, you are exposed to the internet, you are exposed to the Google Kalli, but everything you can look into it and even read from that. Even the courts are also following it. Even please remember, sometimes the Google Kalli also gives you wrong information. So be alert, be a reader always, and always think that you are a learner. Don't think that I know everything. If you feel that I know everything, there is nothing for you to learn and you are fooling yourself. So first and foremost is cross-examination is an art as well as a science. It's an art for the simple reason every person cannot master the art of cross-examination. It requires skill, it requires experience, it requires following up and also following the basic intricacies and technicalities of law. This is more achieved by watching seniors conducting cross-examination in courts. Please don't spend your time in the bar room or in the ladies' room, spending your time there chit-chatting. Please sit in the court where a senior is conducting cross-examination. Sometimes in your own case, it may be useful to you what are the techniques he adopts as far as cross-examination is concerned. That is the reason it is said cross-examination is an art. And also, it is not mastered by reading any number of books or any number of Google placements, so on and so forth. It is learned mostly by experience and also by skill and also by what is called avagahana, that is having knowledge of it and be aware of that. And please remember, all of us commit mistakes in the initial stages, but learn from your mistakes. Please remember, a doctor, also a surgeon, does not become a surgeon overnight unless he kills 10 people. He learns from that. I have committed this mistake, let me not commit it again. So a cross-examiner should be a thorough learner, thorough reader, and thorough mastery over facts and documents. And when you commence the cross-examination, you will have to go through the pleadings as well as the documents which are on hand. And then when you go through the pleadings means under Order 6 is defined as plain as well as the written statement. And also note down the admissions, contradictions, inconsistencies in the pleadings as well as in the evidence. And one fundamental rule in the law of civil procedure is, Order 6 Rule 2 says, plead and then prove, not prove and then plead. So you'll have to be very careful in drafting a plea. Always when you draft a plea, you try to keep your client before you and take proper instructions and draft it accordingly. Don't mind writing it again and again unless you achieve perfection. And think from the other side's point of view and how the other side will beat your case, how he is going to conduct his evidence, so on and so forth. This is achieved mostly by observation, mostly by following seniors, mostly by following the pleadings, following the documents, and also noting down the inconsistencies, contradictions, and admissions made by a party. Please remember now the originality also is gone thanks to the amendment of the Civil Procedure Code by Act 22 of 2002, effective from 1/7/2002, whereby they brought in 24 or 26 amendments. Here, if you just go through it, I cite one, Order 18, Rule 4 and 5. It says all evidences in chief has to be filed, shall be filed, not may, shall be filed by an affidavit. Please remember, this is nothing but to make judges avoid their duty. Judges, one useful thing they were doing is noting down the evidence, page by page, para by para, so on and so forth. Now everything is available. Please remember, when I came into the profession, judges didn't have the stenographers, judges did not have the typists. Now everything is dictated to the typist types it. And please remember, your computer also is not it does not have a mind, it does not have a conscience, it does not have a body. Whatever information you feed into the data, it comes whether right or wrong. That's the reason you must be a keen observer when cross-examination is made. Don't bother about chief examination. Chief examination is nothing but parrot story of the plaintiff's case or the defendant's case, whatever it may be. Then while drafting the affidavit also, please remember there's a tendency of the advocates not using their brains. What they do is straight away they go to the typist. Chief examination kotti petran. What jurisdiction is a court fee is a prayer is a. Please remember there are high court circulars to say that your evidence cannot be a substitute to the pleadings. Whatever testimony you would give it to the court should be sum and substance of it would be the evidence. You should not write everything. Then next one, that's why I said that cross-examination is an art and it cannot be mastered just in a jiffy. Then the question arises, why is it a science? It is called a science because it requires specialized knowledge, specialized skill, specialized learning, specialized awareness, and specialized presence of mind. Please remember, when you are conducting cross-examination, don't divert yourself from the point on hand. And please remember, it's always advisable for you to keep the questionnaire ready with you, because in civil matters also you've got the pleadings, you've got the documents, and you've got everything with you. There's nothing for you not to have it. So there what you do is you prepare a questionnaire, in what form you must ask the questions, and what form the questions should be formulated, what form the evidence or testimony of the witness has to be shattered. In this regard, I would suggest that you must act like a psychologist. That is, you must observe the psyche of the witness who appears in the witness box. First, there are 4 or 5 types of witnesses. One is a timid witness, one is a 50-50 witness, one witness is comes there only to speak falsehood, and one witness is a person who speaks only the truth, and other witnesses, he tests the skill of the cross-examiner. And that is the reason when we commence the cross-examination, we say, where are you working? How many children you have got? What's your wife doing? Is your wife working or is she at home? Or only cooking food for you? Please remember, these are all not relevant things as far as the cross-examination is concerned. A clever cross-examiner, what he does is, he puts the witness into a frenzy. After all, there is nothing. There you insert the proper question and then try to elicit the answer. And when you get a favorable answer, don't go to that question again, because you will be giving an opportunity to the witness to correct himself. So that is why it is called a science. Everyone cannot master the art of cross-examination, be it civil or be it criminal. And you will have to build it from the foundation. And there are 2 types of practice in the civil side. One is called the trial action and another is called the appeal action. As far as the trial is concerned, your presence of mind, your skill, everything is involved. You have to lay the foundation of the case, or what is called the bunyad, as far as the case is concerned, on which the edifice of the case stands, or the your suit or defeat or win stands. So stronger the foundation, stronger the superstructure. So cross-examination, that is the reason it is always called a science. It cannot be mastered by reading any number of books or any number of treatises, any number of Googles or whatever it is. So the question is, try to use your own brain. Don't live on borrowed brains. Please remember, if you've got a senior, don't feel shy of asking your senior, sir, how to proceed with this case. I don't think any senior will allow a junior to do the cross examination. Why? Because the client will be at his throat. Sir, fees aapko diya, sir, aap hi karna padta. The question is, sometimes it so happens, sir, the senior cannot be present in all the courts at all the time. Sometimes we'll have to depend on the juniors for conducting a case. In this regard, I refer to two systems of drafting which is prevalent. One is called the Anglo-Saxon method, Anglo A-N-G-L-O space, Saxon S-A-X-O-N method, and American method. As far as Anglo-Saxon method is concerned, it is a complex sentence. That is, right from the first word to the last word, blah, 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 is one paragraph. You do not know where it has started, where it has ended. It is something like Telugu films nowadays. See, previously, I still remember olden days, when I was young rather, we used to watch films like Batti Vikramarka, Balanagam, Maranagama, and so on and so forth. There, right from the beginning to the end, we watch it because everything appears new. And please remember, your neighbor will say, Yentavaraku hero ochida, heroine ochida, villain ochida, కొట్లాడుకున్నారా దేనితో కొట్లాడుకున్నారు కత్తితో కొట్లాడుకున్నారా పిస్టల్ తోటి కొట్టుకున్నారా అప్పుడంతా పిస్టల్ లేదు గిస్టల్ లేదు కత్తి రాజనాల అండ్ ఎన్టీఆర్. So the question is, things change by time. So the question is, what I'm trying to tell you is, you must develop awareness, skill, and experience. Please remember, awareness, skill, and experience is not learnt in a day. You have to wait. And please remember, this profession is not a ready-made profession, sir. You have to slog, like especially when you're appearing on the trial side, especially the lower courts. But please remember, one judgment of the Supreme Court is widely criticized is, even if a law graduate has only one day in practice, gets enrolled, they can become judges. Please remember, that's a wrong notion. Why? Because it takes you 5 years to learn the alphabets as far as law is concerned. You may be a gold medalist, you may be a distinction student. I'm telling you, most of the lady advocates here, because most of the judges today, because of the 33% reservation, lady judges are being appointed. Sometimes they're outnumbering men also in the judiciary. I'm not having any aspersions. I got the highest respect for ladies. And even in my office, I got highest respect for my lady juniors rather than my gents. I treat them as my daughters. Because tomorrow, how long I'm going to live? After all, I'm only 75 or 76, at least perhaps for 6 years or 7 years more. But they must take up the mantle and do the case. And they should not spoil my name. So the question is, cross-examination is science because it requires specialized knowledge, it requires specialized skill, it requires specialized presence of mind, and it also requires your application of mind, so on and so forth. Then coming to the American system. American system is, when you draft a plaint, try to draft it as brief as possible with as many paragraphs as possible. If there are 15 documents, let us say, have 15 paragraphs, so that even if the senior is not there, the junior can conduct the case. The question is, all right, this paragraph, this document, this paragraph, this document. Like that, American system is more advisable to follow rather than Anglo-Saxon method, which is followed by the Commonwealth or the English people. Then coming to the subject again, here you've got different types of suits. For example, money suits, mortgage suits, title suits like specific performance, etc. And most the hot topic is injunctions. There is a good joke about injunctions. Injunctions is spelled in a different way by different professionals. Injunction, as far as an advocate is concerned, injunction means a prohibitory order or a preventive order which you take from court. And you come to an advocate and ask him, sir, get me an injunction order. When you go to a surgeon or when you go to a doctor, sir, please give me an injunction. He says, I do not know what injunctions are. I know only one thing, that is injection. So there's a spelling difference between injunction and injection. So have a thorough knowledge about it. Then there is one more thing. I'm only dealing with the theory part of it and then coming to the practice. Then one more thing, what is the distinction between an injunction and a stay order? When I was working in the university, a particular professor was asked, sir, what is the distinction? Then this man said, sir, I have not gone through it, I'll tell you tomorrow. The same student got up and said, sir, what is the difference between injunction and stay order? Then third day also he asked the same thing. Sir, what is the difference between injunction and stay order? Then this man said, so-and-so is teaching civil procedure code. You kindly go to him and ask. He will give you a practical exposition what is the difference between an injunction and a stay order. I will give you that because I have raised that topic. Injunction means a preventive order, a prohibitory order, restraining a person from doing a mischief which he has started, about to start, apprehended to be started, or in the process of being started. You take a prohibitory order or preventive relief to stop that particular mischief being committed. That is called an injunction. Stay is when an order has already been passed against you and it has become operative, when you want that order to be kept in suspended animation till your appeal is heard, that is called a stay order. So here, what is called injunction promotes what is called inactivity, but as far as stay is concerned, it promotes activity in the sense the lower court is one. Please don't take cognizance of it. I am seized of the matter. I will decide the matter in appeal. That's how there's a distinction between an injunction and a stay order. Then one more mistake which we commit in the real practice is, even assuming for a moment you take a temporary injunction. Please remember, person who wants to violate the order does it in any way. You want him to stop the construction. There is an injunction order preventing him from doing it. But what that person does is, even in spite of the injunction, he commences the construction, completes the construction. Then the question is, even if you take a decree for permanent injunction tomorrow, you will have to hang it on your neck and then parade it. You cannot execute it. So for that reason, whenever such scene occurs, your duty is to amend the plea and ask for the additional relief of mandatory injunction also, as laid down in section 39, and also add those paragraphs and add one more prayer and value that for the mandatory injunction, you get a concrete relief. If you don't do it, please remember that perpetual injunction decree is of no consequence as far as you are concerned. Then I don't want to go further into CPC. There you got disobedience, Order 39, Rule 2A, where it says, suppose a person violates the injunction order as far as disobedience is concerned. Like that. Then it's your duty to send a copy of the plaint, copy of the petition, copy of the affidavit, copy of the material papers to the opposite side by registered post and file an affidavit under Order 39, Rule 3 of compliance. Unless you file that, your injunction orders will not be communicated to the opposite side. One more thing you remember, most of the advocates forget is, that is whenever an injunction is granted to you, as a matter of right, you are entitled for a carbon copy of the order. You can file a memo to the court, affix 2 rupees stamp, your carbon copy is given to you. You need not wait till the certified copy is given to you. So that even tomorrow, you can go to the police and show it and say, sir, I've already obtained an injunction, still is going on with the construction. Then one more $1 million question I was told, I think when I was having the class yesterday, one of the students asked me, sir, here in lower courts, what they are doing is, even if I take an injunction and file a petition for police protection, for the courts are not entertaining it. Courts are asking me to file what is called an execution petition under Order 21, Rule 32 for enforcement of the injunction order. Please bear it in mind. Order 21, Rule 32 applies only in such cases where the suit is disposed of, not earlier. But the proper remedy would be to file it under Order 39, Rule 2A for disobedience. Then there is a detailed judgment of Justice Sumalata passed in 2020, which has discussed the complete ambit of police protection, right? Starting from AR 1959 AP, Justice Gopal Roy Kote's judgment, where it says only the police can implement an injunction order and court cannot do it. The police assistance will have to be given whenever an application is filed for police assistance under Section 1, that is in that is part of CPC, that is 151, courts are bound to grant police protection. So that is the theory part of it. Now coming to the cross-examination. Here in money suit, what are the points you can take, sir? Normally, money suits are filed in respect of negotiable instruments, mostly if I'm correct, promissory note, receipt, check, so on and so forth. When it is filed, there are certain defenses which are open to you. What are those defenses, sir? For example, discharge of contract, Section 56 to 63 of the Indian Contract Act, which speaks about doctrine of frustration, doctrine of novation, doctrine of revision, doctrine of alteration, doctrine of modification, or doctrine of variation, which is provided to you under Section 61 and 62 of the Contracts Act. These are the defenses which are open to you as far as the Contracts Act is concerned. Can you tell me what are the defenses open to you under the Negotiable Instruments Act? That is a gold mine for all of you now, because most of the cases which are filed are check bounce cases under 138. For a moment, 138 is easy and understand, but there are some intricate positions also available. Here, you have got 118 of the Negotiable Instruments Act, which speaks about golden presumptions under the Negotiable Instruments Act. Presumption as to execution, presumption as to consideration, presumption as to the date, presumption as to the person who has drawn the document, presumption as to the person in whose favor it has been drawn, and presumption that the person holding that document is a holder in due course. Please remember the word that is used there is not may, it is shall. How to overcome this? In the Negotiable Instruments Act, when you file it under 138, let us say, you have to give first, you will have to deposit the check, isn't it? When you deposit the check gets bounced. The day of bouncing is not counted. The next day you must issue a notice giving how much time? 15 days time has to be given to the opposite side to pay the money. If it does not pay the money within 15 days, then the next alternative open to you is within 1 month, you can file a complaint before the concerned magistrate who has got jurisdiction. And along with the complaint, you are also supposed to file the sworn statement. And sworn statement, strictly speaking, according to the law, it has to be recorded by the judge in our own handwriting. But they are not doing it. They are asking you to file a type copy. Just court passes it and says, yes, taken cognizance, number the CC. It's numbered as STC. STC means summary trial case on the NI side. STC NI. Then you've got new provisions which have been added. 143, 143A, 144, 145, 146, 147, 148, and 149, which speaks about the provisions which were missing earlier. For example, there they say the courts are also got the power to grant interim compensation, also like interim maintenance. They say interim compensation also can be awarded, that it should not exceed 20% of the check amount. And suppose the accused succeeds by getting the CC dismissed, that money which he has paid, he is entitled to get it back from the creditor along with the interest within 6 months from the date of order. Then one more thing is, there they say that 145, how the summons have to be sent. Summons have to be sent by the court as well as by registered courts in the usual process, that is to the residential premises or to the office premises of the person concerned. Then next provision you have got grant of interim compensation. Court, irrespective of the trial, lengthiness of the trial, can grant interim compensation to the complainant. Then the next provision which is included is, there they say that even the delay in filing the complaint can be condoned by the court. That is a new provision which has been brought, and also provision has been made to what is called filing of evidence affidavits. In STC NI cases, evidence affidavits can be filed, and all cases under the NI Act are summary in nature and they have to be disposed of within 6 months. And when an appeal is filed against the conviction order, the fine has to be paid. But as far as suspension of the sentence is concerned, 20% of the check amount has to be deposited by the accused when asking for stay or asking for suspension of the sentence. Then one basic thing you must remember is 138 has to be read with 142. 142, most of us forget. That is, a check bouncing case is maintainable only when there is a pre-existing monetary liability. There must be a promissory note, or there must be a receipt, or there must be some document to prove the primary liability. and towards the primary liability, the check has been given, and when the check is presented, it gets dishonored, which gives you a cause of action, right? In this regard, I cite the judgment of Justice Seshasayana Reddy of the then Andhra Pradesh High Court, who said, jurisdiction of the iyenagar cases. There he said the check bouncing cases have to be filed in the court where the accused resides. You cannot file it in the place of the accused. Check on which bank given within whose jurisdiction. Check where presented for encashment, where it got bounced, and the particulars of the check number and date, on which bank it has been given, amount actually due, amount less paid, and amount actually due. That is how a statement has to be given in your complaint itself, so that it is easier for the judge to follow and easier for you to conduct the evidence. So one basic thing you remember is that 138 is always subject to 142. So unless 142 is satisfied, a complaint under 138 is not maintainable. That is a classic rule which you have to follow. Then in Chennai and some of the presidency towns, they follow section 139. 139 says, irrespective of the length of the case, irrespective of the duration of the case, what happens is, suppose the court comes to the conclusion that the accused is guilty, double the amount can be awarded. That is, one amount goes to the state and one amount goes to the complainant by way of compensation. But that is not followed by the provincial towns like Hyderabad, like Telangana, as well as Hyderabad or other places. So this is, and when you conduct the cross-examination, the most important defense that is open to you is material alterations. Material alterations. Most of you are using ballpoints now. You just check it up with your ballpoint. When you use your ballpoint, when you want to copy someone's signature, you stop there. Suppose the word M is there. In that you stop. There's smudging there at that place. There is a dot there. That is overwriting. Or let us say, there you find a dot. That is, it means the signature is thought to be tampered. Then date. Date, please remember there are some numerals which you can change into different numerals also. For example, 6 you can make it into 8. 2 you can make it into 8. 1 you can make it into 7. And 6 you can